Well, hello and welcome to episode 10 of the Wright County Restoration Project podcast. We are now in double digits
We are.
of our podcast, and that is an exciting thing. Very happy to be here. My name is Jamin.
And I'm Sam.
And we are here to talk about at least the 8th Amendment today. Probably going to try to get into the 9th as well. There's some content here to cover, and we are quickly approaching the end of the Bill of Rights.
We are, at least the portion that we see as being initially given by the founders and what they laid out there. And then there's been subsequent other ones added and even some kind of done away with, as we see with the amendments regarding prohibition. But these are the first 10, and that's a great place to start.
Yeah. So we should hopefully, if all goes well, finish those up next week, and then we can move on to other things. So we'll begin with the 8th Amendment, and I'll just go ahead and read it, and then we can jump right into it.
Sounds good.
The 8th Amendment says, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted." So as we've seen with many of the amendments to this point, it's short, it's sweet, it's clear. Maybe it would have been nice in one sense to have a little bit more elaboration on certain points. It would have helped us today. But this is such a stark contrast to the great omnibus bills and things that we see today. So let's go ahead and start walking through it.
Yeah. Well, I think it's interesting, you look at this, and this is kind of, we're kind of wrapping up. We've been talking about a lot of different amendments that have to do with the legal system, with how the legal system deals with someone who is either breaking the law, have a grievance against someone else due to property or such. And so this kind of wraps that up and is specifically talking about what the government can do to someone who has broken the law. We went through the courts. We talked about trial by jury, those kind of things, and now we're talking about once someone is found guilty, what can the government do, and what can it not do to its citizens? And this is something that historically we see quite a bit of what we would probably consider barbarous acts or very crippling acts versus where someone was fined a very large sum, or someone was a very high bail was set, or these type of things, and this is what the founders are trying to at least set a precedent here for, and trying to make a clear line for the government that it shouldn't cross. Whether those things still probably need to be revisited as well. And like you said, there's not, at least in the actual bill, there's not a clear definition of what these things mean. You hear a lot of different things about what cruel and unusual means, or excessive in this amendment. But it's interesting. Over time, those things have played out and probably will continue playing out.
Yeah, and as we think about this, I kind of think about it from two different angles. The first angle being as it relates to the people. When there is excessive bail, or there is these fines that are crippling, excessive fines, and perhaps we can talk through a little bit of that in a moment. But also from a corruption standpoint, again, we see how many of these amendments are actually meant to limit the government, and particularly limit the nature of man to become corrupt.
Yes.
And as we think about bail, fines, and then of course punishment, these are basically the three ways that the justice system can get you.
Right.
They can hold you, and then there's the bail system, which allows you to be released, and then they can fine you, or they can imprison you and punish you. And so it really, though it is general, it does in a very broad way keep the government, again, in check as it relates specifically to man's corruption.
Yes, absolutely.
So we see this here, and as we talk about bail, this is that first clause: excessive bail shall not be required. And what are we dealing with there?
Well, when you look at especially early English law and then continuing on, there's many different times when bail was used in a improper way, and where it was used to really punish poor people, and there's still people who discuss that today in our justice system, where bail gets to be a certain point. Now the thing with bail is it can't be too high, because as we're seeing here, that just becomes a burden that someone can't bear. But then the justice system would say, well, if it's too low, someone will just skip the court. It
Right.
nullifies the gravity of the situation, and so there needs to be that proper amount of money held in bail to make sure that someone shows up to court, and so that's an interesting thing, and something that the founders, obviously because they put it in here, were felt was important, and that first excessive bail clause was something they put in here. We'll see there's two other clauses, the fines clause and then the cruel and unusual punishment clause, and each one of those, like you said, has to do with how the government interacts with its citizens in a criminal justice case.
Yeah, and I suppose we should explain just briefly for anyone who might be listening a little bit of what bail is. So when a person is waiting to have their case tried, there are times where the justice system can tell a person that they put down a certain amount of money and it will be held sort of in escrow, I suppose.
Right.
And with that money being held, then the person is allowed to be released, is allowed to, depending on the nature, generally released on their own recognizance for that time. And then they are given a court date, and if they do not show up to their court date, then that money that they gave to the courts would be kept, and they would forfeit it.
They skip bail.
They would skip bail, and so that way they are held to account while simultaneously being able to get out and do the things they need to do. And this was important, even as we talked for the last couple of weeks about this idea that if the courts could indefinitely hold someone without trial, whether that be for the high offenses or whether that be for something lower, then a man could lose his home. He could lose his his family's not provided for. There's a great deal of inconveniences and perhaps damage done to him and to his livelihood if he's not able to get out. Now, we do see today a couple of different ways that bail is administered. And one of them, as it relates to trying to avoid this concept of excessive bail, is that a lot of times the court system will set a bail amount based upon a person's income or a person's assets. So if they have assets, if they have high assets, a lot of money in the bank, or a good amount of income, then their bail would be set higher, and it would be a percentage of that income, in order that every person has the ability to make that bail if they'd like to. And then, of course, there's only a percentage of that. And then if you go through a bail bondsman, then you're paying them a percentage and such as well. But the other thing that we also do see is in certain cases where the crime is gross, or if there is a high risk. Of course, then the bail, a flight risk for one reason or another, that they will not show up to their court date, or if it's not worth it in the justice system to potentially lose this person, of course, the bail will go up. So that's the concept of bail, and that's what the founders wanted to protect their citizens from, is someone being held in prison specifically because for a certain person, maybe it's a political dissident or someone that so-and-so didn't like, some judge or whatever it might be, they can just make the bail so excessive, so high, that person is stuck. And then, of course, if they were able to compound that with a slow trial, dragged on trial dates, many continuances, then again, you could, in theory, and probably not in theory, I'm sure many times in practice, destroy a person's livelihood on false charges without ever even having to prove anything against them.
That's true. Very true. Well said.
So what else do we have here?
So as kind of moving on, we kind of it rolls into the excessive fine clause, and it's interesting because we look back in much further history, even further than the founders, quite a ways back, to a document called the Magna Carta. The Magna Carta, just a brief history on it, it's kind of looked at as one of the first documents where the people, in this case it was the lords and kind of the landholders of England, actually marched in battle formation and in battle array on their king. At this time it was King John III, and he was ruling and reigning in such a way that was very odious to them. He was acting upon something that, as we call it in history, the divine right of kings. Basically, he was saying, I have the right to do whatever I want to do, even if you are a landholder or have, a lordship or whatever, you have to obey me without question. And the people rose up against that, and in a way, through forced the king's hand to sign the Magna Carta in 1215. And then it was rescinded by the Pope at that time through a bull, and then it came back and forth. But it's a very pivotal document in history as far as the first kind of glimmer of liberty that we see kind of coming out of the Dark Ages. So after that brief history, let's look at that document and what it talks about in regards to this. So it doesn't cover the bail clause, but it does cover the excessive fines and the cruel and unusual punishment clause. So here's a quote out of the Magna Carta. Again, this is from 1215. A free man shall not be fined for a small offense unless according to the measure of the offense. And for a great offense he shall be fined according to the greatness of the offense. And so the Magna Carta was the first English document that placed restrictions on the sovereign, that would be the king, from violating certain agreed upon rights of the people. So it talks about this fine thing as saying these fines shouldn't just be arbitrary, they should be kind of in nature of the offense to the king. So that's kind of where we first see it. We also see it played out, and we have more information coming in with Blackstone's commentary on English law, which comes a bit later, but it's also something that the founders drew from when they were writing those documents. So here's what Blackstone has to say on this. However unlimited the power of the court may seem, it is far from being wholly arbitrary, but its discretion is regulated by law. For the Bill of Rights has particularly declared that excessive fines ought not to be imposed, nor cruel and unusual punishment inflicted. When he's talking about the Bill of Rights, I believe he's not necessarily talking about our Bill of Rights, but he's talking about other bills of rights that are out there. But he was specifically talking, and I believe this is pre our Constitution and Bill of Rights, but talking about how excessive fines were something that should not be imposed. And then we also see this cruel and unusual punishment clause, and we see that wording come back here in the Eighth Amendment.
Yeah. Now, as we think about that excessive fines and excessive bail, and really much of what we've talked about over the last several weeks within the legal system, there is biblical precedent for this idea. We'll talk about it again in cruel and unusual punishment in a moment as we think through how that has been applied to our justice system today. But in Deuteronomy 16, beginning in verse 18, the Bible says, and this is in the law of Moses, "Judges and officers shalt thou make thee in all thy gates, which the Lord thy God giveth thee, throughout thy tribes, and they shall judge the people with just judgment. Thou shalt not wrest judgment, thou shalt not respect persons, neither take a gift, for a gift doth blind the eyes of the wise and pervert the words of the righteous. That which is altogether just shalt thou follow, that thou mayest live and inherit the land which the Lord thy God giveth thee." So we see this idea here, and it's a fairly vague idea, the idea that you are going to do this with justice, you are going to do this fairly, you are going to do this in a manner that does not pervert justice or does not pervert wisdom. And then we also see, and it's more about commerce, but in Deuteronomy 25, speaking of this element of money itself, beginning in verse 13, the Bible says, "Thou shalt not have in thy bag divers weights, a great and a small. Thou shalt not have in thine house divers measures, a great and a small. But thou shalt have a perfect and just weight, a perfect and just measure shalt thou have, that thy days may be lengthened in the land which the Lord thy God giveth thee. For all that do such things, and all that do unrighteously, are an abomination unto the Lord thy God." So this speaks to both commerce in the street and then commerce in the house, as it were. This idea of false measures or diverse weights. And the idea would be that if you are on the street selling and you're selling food, or you're selling something by its weight, so you're selling an ounce or 10 ounces or 12 ounces, and so you have in your bag different weights that say 12 ounces on it, so that you can either, if you're buying, you're going to use the weight that is heavier, so that you'll get more for your money, and if you're selling, you're going to use the weight that's lighter to get to give less than what people are buying, and the Bible talks about this as being abominable to the Lord. It's dishonest. It's unjust. And we see in both of these concepts, as well as any number of examples throughout the Old Testament, this idea of, as we think of excessive bines and bail and excessive fines, this call simply to justice, that we would treat one another, and that the legal system would treat each citizen justly, not as we think of, not as justice is defined today, which of course is actually pressing for injustice, to treat certain people better than others based upon inherent characteristics or choices, but truly justice, this proper weight, this proper balance.
Absolutely, and that's very clear throughout the Bible when we see how God seeks for one to treat each person equally in that sense, especially in business, as it talks about there, and especially when it comes to the poor, the needy, the fatherless, those types that, there's specific places in the Bible where God says, "I will hear their cry if you are defrauding them." Someone who maybe isn't as sharp or business savvy to be able to catch you when you're using a different weight or different measure, or talks about even moving the barriers and lines in a field of that nature, that God that justice, that just scale is something that's extremely important to God.
Yeah, and we even see that, of course, in the picture of justice that the founders would erect, which is that woman with a blindfold and a scale in one hand and a sword in the other, and that was supposed to be Lady Justice, and she was blind because she was weighing only by that which was just, and if there was a false weight in her hand, then of course there would be the appropriate punishment meted out. And so very, very intrinsic to the nature of the founding was this idea, the biblical idea of true justice.
Absolutely.
And that brings us to cruel and unusual punishment.
It does.
What is this about?
So cruel and unusual punishment is interesting. I mean, we can go very far back into history and see all kinds of cruel and unusual punishment that's been meted out by various kingdoms. I mean, even thinking about to Christians, the cross is a very important thing, and we have maybe glorified it a little too much in some way, shape, or form. But it's and you wouldn't normally see somebody walking around with a guillotine on a necklace, but they're both. And actually, the cross was designed specifically to be cruel and public. The reason the Romans really perfected that form of punishment was for seditionists. They were looking to really punish and make it very clear, very public, in a public place, and so that it burned into everyone's mind the idea that there's no way I would ever want to try to subvert Rome, try to throw off Rome's power, because that's what happens to you. And this plays out throughout the Roman Empire, and then into the we see it in the Dark Ages. We see it playing out through much of early Renaissance and throughout Europe is this idea that kings and rulers would have very public and very gory and terrible ways of putting people to death, various things. It's interesting. So all these things kind of come to, when we're talking about this cruel and unusual punishment, it's become a very nuanced argument in our day and age, but a lot of these things are what is I'm sure bearing in the minds of the founders. We see in 1878, there's actually a Supreme Court case, Wilkerson v. Utah, that the Supreme Court kind of puts a little more information in there in what they thought about this cruel and unusual punishment. And just a few of the things that they talked about were commented that, and these are the execution punishments that they said are always off. These would all fall under cruel and unusual punishment. They said drawing and quartering, burning alive, disemboweling, and public dissection would constitute cruel and unusual punishment. I don't think any of us would question that, but these are the type of things that, even at this time, which is, after the Civil War and many things, that people are saying this historically, these have been punishments. These are things that, and clearly here in the Bill of Rights, these are off the table. These are not, we don't even think about these. Now, of course, to us right now, that really seems unheard of. But these are the type of things that have been going on, even before Christ, that rulers have been using to put down sedition, to put down and even punish criminals who maybe were even worthy of death, but they would punish them in such a public and gory way that was just something that in a Christian country, in a country that loves life and protects life, and also the dignity of the human being, even if someone has done wrong, is just not something that the founders ever wanted to see happen in this new United States.
Absolutely, and it is an interesting balance that we see as we think through this, because as you talk through the nature of the cruel and unusual punishments that were listed there in that Supreme Court case, we find that this twofold motivation, right? The first of those motivations being that this would be extremely painful and it would be suffering. So you are putting a person to death, but you are causing them to suffer for extended periods of time prior to putting that person to death. And that is, in many ways, an offense against human dignity. And then you see this idea that by doing this very, very publicly and openly, you are hoping to divert others who might be thinking toward crime and
Right.
toward whatever it might be, whether that be sedition or other capital offenses. And while we would recognize the natural human dignity and the importance of maintaining natural human dignity and not bringing a person in a civilized and Judeo-Christian society through a tremendous amount of torture and pain, and this is not foreign. We think of many countries today, the despot countries, the tyrannical countries,
Right.
where this kind of torture, especially in those Asian countries, as we think of Korea and Vietnam and those wars and the POW camps and the kind of torture that people would face as they ignored the Geneva Convention and such, these things would be just an affront to human dignity.
Yes.
But that does not mean necessarily that there should not be some measure in a society of I'm trying to think of the exact word. Deterrence is the word I'm looking for to crime.
Yes.
And that brings us to kind of how cruel and unusual punishment is interpreted today.
Yes.
And so we have a scale of cruel and unusual punishment, going from using, say, for capital offenses, lethal injection, within a jail setting, making sure people get 3 meals a day, making sure they have access to proper hygiene products so that they can clean themselves. Again, going back to capital punishment, we talk about firing squad and hanging and all of the different ways that we've seen it. And we see those elements, but then it is very much up to interpretation, because now we're getting to the point where if a man complains that he can't get his vegan diet in jail, then he invokes the cruel and unusual punishment clause. Or if a person might look at capital punishment as a whole, the idea of taking the life of someone for an offense of taking the life, or from an egregious offense such as rape or whatever it might be, and even the act of taking their life is now on the block as perhaps being cruel and unusual. And it's this that I want to speak to for just a moment. In the Bible, we find various ages of history, and with each successive age that we find, important points, we might call them epochs of history, where God intervenes in some unique way. We also see him add revelation and add accountability to man. One of the first epochs that we see of history is after Adam and Eve fall to sin. There is this time where man is operating according to the dictates of his conscience, as it were. Man knows good and evil. That's what happened in the garden with the fall. And the question is, can man's conscience, can man's inherent moral knowledge compel him unto that which is right? And what we find is that throughout the course of that time, in the first chapters of Genesis, man does the exact opposite. So that a number of generations in, the earth is only violence continually, the Bible says. And so many of you probably know the historical account of the biblical flood. God chooses a man named Noah. Noah builds an ark, a very large boat, and not only can it house all of the different kinds of animals, of which there were probably not that many when you actually bring it down to the kind level of an animal species. Wouldn't have to take a dog and a dingo and a fox, wouldn't have to take a lion and a tiger. You just have to take one that has all the genetic material necessary for all of that diversity. And so we think of this, and there was more room in the boat, of course, most likely, so that anybody who would believe could be a part of that deliverance. But only Noah and his wife and his 3 sons and their wives get on the boat. And God judges the world and destroys the world, and then reinitiates humanity through Noah and through his sons. And as we find this transition into this next age following this great flood, we read this in in Genesis chapter 9 about Noah and his sons. The Bible says, "And God blessed Noah," this is Genesis 9 verse 1, "and his sons, and said unto them, Be fruitful and multiply and replenish the earth. And the fear of you and the dread of you shall be upon every beast of the earth, and upon every fowl of the air, and upon all that moveth upon the earth, and upon all the fishes of the sea. Into your hand are they delivered. Every moving thing that liveth shall be meat for you, even as the green herb have I given you all things. But flesh with the life thereof, which is the blood thereof, shall ye not eat. And surely your blood of your lives will I require. At the hand of every beast will I require it, and at the hand of man, at the hand of every man's brother will I require the life of man. Whoso sheddeth man's blood, by man shall his blood be shed, for in the image of God made he man." And so we see this idea very, very early on, and we count this to actually be the first institution of government, whereby there is a body of men who are able to govern, who God has delegated the responsibility of governing the actions of other men. And the delegated governance is simply this, that if a man or a beast take the life of another man, he has irrevocably marred the image of God in that man. And the image of God is so valuable. This is intrinsic human dignity once again, The image of God is so valuable, intrinsic human dignity, made in the image of God, is so valuable, the very thing that gives us life, liberty, and property in the sense of the founding, is so valuable that if man or beast shed man's blood, then that man or beast must be killed. And we've talked about this before, as we've talked about human dignity. But this is, of course, the foundation for this idea of capital punishment, and it was not without a measure of legality as well. As we get again into the law of Moses in Numbers chapter 25, beginning in verse 30, the Bible says this: "Whoso killeth any person, the murderer shall be put to death by the mouth of witnesses. But one witness shall not testify against any person to cause him to die." You have to have more than one witness. You can't just have one. We talked about that a little bit already in another episode. "Moreover, you shall take no satisfaction for the life of a murderer." The idea being the life of a ransom. You shall not take any amount of money to keep a murderer alive, which is guilty of death, but he shall surely be put to death. "And ye shall take no satisfaction for him that is fled to the city of refuge, that he should come again to dwell in the land until the death of the priest." And this would be the idea that if a man is actually a murderer, that he is not able to find within the justice system, and maybe we'll talk about the cities of refuge another time, but he will not have in the justice system any quarter, any relief from this punishment that is his own life. Verse 33, "So ye shall not pollute the land wherein ye are, for blood it defileth the land, and the land cannot be cleansed of the blood that is shed therein, but by the blood of him that shed it. Defile not therefore the land which ye shall inhabit, wherein I dwell, for I, the Lord, dwell among the children of Israel." Now, naturally, we are not Israel, and the law of Moses is not the law of our land, nor is the law of Moses by de facto God's law imposed upon all men for every generation. However, we do see a principle here that harkens not back to the law of Moses, but harkens back to the very image of God and man as it relates to this, so that we can comfortably say, firmly say, and unapologetically say as believers that capital punishment is not cruel and unusual on its face. That there are ways that capital punishment can be meted out that are cruel and unusual.
Absolutely.
But that capital punishment itself should not be considered a cruel and unusual punishment.
Absolutely.
Do you have anything else on the Eighth Amendment?
I think that pretty much wraps up what I have. I think it's interesting to look at how, as you were saying, very clearly we see biblically that there is a case for capital punishment being something that God specifically says, throughout His Word, and it specifically calling back to that man is created in the image of God, and that's something that we need to probably remember more as we look at these things, and how that is, the taking of a life is an affront to God just by the very nature of mankind being in His image.
Yeah. Well, that brings us then to the Ninth Amendment, and we're going to try to get through as well. Do you have it there? Can you read it for us?
I do have it.
Let's do that.
So the Ninth Amendment, another short one. "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people."
What does it mean?
What does it mean? Well, this one is interesting, and it brings us back. Kind of, maybe we step away from the microscope a little bit. Look at the big picture. What was going on? Why is there these 10 amendments tacked on to a constitution? And at the Constitutional Convention, when they had wrapped everything up, everybody was pretty happy with the documents. A few members got up and said, "Wait a minute, we don't have a Bill of Rights with this thing," and several of them would not sign that document until there was a Bill of Rights. And this goes back to kind of a bit of a political, two political sides that were there at the time, and different men were on each side, and we would call them the Federalists and the kind of the anti-Federalist sides. And I'm going to go into a little detail of of what each side stood for and why this Bill of Rights, this whole Bill of Rights idea was somewhat kind of controversial, and some people did not want it. You may say, why would you not want it? Well, I'll get into the history, and it may make a little more sense, but looking at it historically, I think it was a good idea.
Sure.
So you have these two sides. You have the Anti-Federalist Party, and that side has men such as Thomas Jefferson, Patrick Henry, and George Mason, a part of this Anti-Federalist. And their opinion was that they really needed this Bill of Rights. They were afraid of a government, even a government that was designed with this Constitution that they just come up with, of that government basically not knowing, or not knowing is maybe a nice way to put it, of overstepping its bounds, of stepping on the citizens' rights, of taking those rights, and that there was no real safeguard for the people. And understandably, this makes a lot of sense looking at it from our position many years after the fact. So you have, on the other side, you have men like John Adams, James Madison, who was kind of the initiator of the Constitutional Convention, and he kind of was one of the fathers of the Constitution, as it were, and Alexander Hamilton, George Washington. Those kind of men were a part of this Federalist Party, as it were, and what they really struggled with, and it's bore out in a couple quotes by James Madison, is that they felt like if you actually put these in writing, that someone could come along later and say, well, all these rights are written down, yes, but that means that anything that's not in these rights is fair game for the government to take over. And so that's what we're seeing here with this Ninth Amendment. We also see it bore out in the 10th Amendment, which we'll get into next time, but it's trying to clearly basically tell the government that just because there isn't something clearly laid out in this Bill of Rights, in these amendments that we have so far, that doesn't mean that it's the government's can just run roughshod over everything else. Yeah. And so it's just interesting to look. I'll just read one of the quotes here from Adams. He's speaking in the first Congress, and speaking about the Bill of Rights. And here's his quote, kind of hearkening back to kind of wrapping up what I just said. It has been objected also against a Bill of Rights that by enumerating particular exceptions to the grant of power, it would disparage those rights which were not placed in that enumeration. And it might follow by implication that those rights which were not singled out were intended to be assigned into the hands of the general government and were consequently insecure. You can see from all the founders' perspective, any rights that were in the hands of the government weren't necessarily in good hands. But he goes on to say, this is one of the most plausible arguments I have ever heard against the admission of a Bill of Rights into the system. But I conceive that it may be guarded against. I have attempted it, as gentlemen may see by turning to the last clause of the fourth resolution. So he's then talking about what they're debating right there at that time. But it's interesting that this was put in there kind of to help both sides be happy with this Bill of Rights document, to basically tell the government that just because things aren't covered in this Bill of Rights, that doesn't mean that the government can move in and take those rights from the people or delegate those rights to the people. There's certain rights that we haven't talked about here, but that it's basically telling the governments to keep its hands off.
Yeah, and this will, as you said, overlap well with the 10th Amendment next week, and this idea of enumerated rights, that it needs to be stated very clearly And again, these waters are getting muddied today in a lot of people's minds, or completely aren't even on their minds. The idea that it is not the government that grants us rights, but rather this document is the people granting the government certain opportunities, certain rights, certain powers. And any power that the people have not granted to the government needs to keep its hands off of. And we are in a point today in our culture where it seems as though people they have this idea that the government should fix everything, that the government confers upon us our rights, that if the government says we can't speak, we shouldn't be able to speak. And of course that's the First Amendment, but that if the government has not granted something to us, that it is not ours. And this is a very common mindset among despots and tyrants throughout the world, throughout time. But this is not the way the United States government, the United States of America, was framed or founded. And that's really what we see here in the Ninth Amendment beginning and will be solidified in the 10th Amendment, that we are to be a nation, by the people, for the people.
Yes.
And that the government is intended to serve us, and that we have the final say in the power that our government has. They do not have that say themselves.
Yeah.
So, anything else here on the Ninth Amendment?
Well, I think it's interesting when you look at the Ninth Amendment and even to the nature, you're talking about rights and how far we've come as a people in understanding even what rights really are. And I mean, we see it where people say people have a right to health care.
Right.
There's a right to all these different things, a right to, and folks on the conservative side would say, hey, we obviously see there's a right to life. The other side would say there's a right to, women to have a right to her body, and with abortion,
right
and those
to privacy,
right to privacy, all those kind of things. And we definitely see that as is taking rights way outside of what the founders saw that as. And so people have used this Ninth Amendment, or it kind of gets batted around because people have taken rights much further than they should be, and also taking it to the point of saying, I have a right to government to help me with X, whatever that is. Where from the founders' point of view, the idea of rights was basically saying, I have the right for the government not to get involved in this, which is completely different than what we see today as people speaking about their rights.
And this boils us back down to these two very, very opposed worldviews that we find in our country today. And really the reason why we're even doing this as a part of the Wright County Restoration Project is, of course, helping people think through what these amendments are and understanding them and a little bit of the history behind them, and seeing how, once again, this document and the principles of the Declaration of Independence, the Constitution, and the Bill of Rights as a part of the Constitution there, the first 10 amendments, are inextricable from the moral self-governance and the moral governance of the Judeo-Christian worldview. And when we shift into a different worldview, really a humanistic worldview, which says that there is no God, that there is no intrinsic human dignity, that dignity is only that which man confers upon himself, then we are getting into a system where the strongest man sets the rules. And it has to be that way within this humanistic system built upon an evolutionary worldview that is a survival of the fittest mentality. Yeah. And so we have seen really since those days of Darwin and then Nietzsche and as communism arose and all of these various philosophies of the 19th and 20th century, we are seeing this battle now come full circle in many ways, to where today, as we're fighting over the definition of the word justice, the definition of the word rights, I'm fighting for justice and they're fighting for justice, but our definitions are so diametrically opposed to one another that there really is no common ground between them. And I would encourage you who are listening today on this level, when you are contending for truth, when you are contending for the founding documents, which, by the way, the founding documents themselves, people are calling for them to be abolished because they're intrinsically racist and all of these silly things. But as you're contending for them today, you need to understand that you cannot just contend for them on the basis of what they say, because we have entirely different definitions about what they say among two factions. You have to start boiling down to, do both people in this conversation believe that truth exists?
Yeah.
Do both people in this conversation believe that there is such thing as natural human rights that transcend governments, that transcend society? Are there rights that are conferred by something outside of our system, that would be God, or are our rights conferred upon us by government and society? If you cannot get a person to admit that there is a higher power that conferred upon us rights, that there are rights that transcend the system, then this document will never make sense to any of them. It just will not work, because this document is founded upon the Declaration of Independence and this worldview that insists on the idea that we have life, liberty, and pursuit of happiness, life, liberty, and property conferred upon us as a part of God's divine rights for us, not governments or men's.
Well put.
So remember that as you're working through this with other people. We cannot be simplistic with this. It's good to know what these documents say, but it's not enough just to tell a person what they say. We have to understand that there's a philosophy behind it, and we need to make sure that whoever we're talking with understands that, at least understands it. If not, agrees with it, before you can really move into debating what are these rights, or what is excessive bail, or what is excessive fines. Okay, we can talk about what excessive means, but first we need to make sure that we both agree in justice, and what the word justice means. That we both agree what this document says, and that we both agree that we have rights that transcend governments.
Yeah, and having that foundation will make a huge difference how you view these documents.
Absolutely. Okay, well, I think that is all that we have time for today, and I want to thank you again for joining us once again. If you have any comments or questions, WCRP, that's Wright County Restoration Project, WCRP at legacybaptistchurch.net. And subscribe, tell others. We would love to be able to see this podcast get beyond where we find it. As we said, we're in double digits, so we're moving right along. And we'll hope to see you and be able to talk to you again on episode 11 next time.